This firm follows a true team approach to the practice of family law. Our clients don't hire me, they hire an us. Every case is assigned a trial team, usually consisting of 2 attorneys and 1 case manager paralegal, usually with 1 attorney designated as lead. Typically, the firm's attorneys triage the cases regularly to determine what's coming up and who's available and best suited to handle each matter. We do this by considering the case, opponent, task, and judge, and try to figure out who could best handle each hearing with what support staff in the client's best interest. What this means, of course, is that we can't, and we don't, give any kind of guarantees as to who will actually perform any particular task in a case, or appear at any particular hearing, all the way up to and including the final trial of the action. We reserve the right to determine who actually does what in any given case. It's the only way that this firm can operate. It's the way we're set up. And those that aren't comfortable with this approach probably should consider hiring some other firm to handle their case. Most documents are drafted in the first instance by the paralegal staff. They're then edited, reviewed, revised, and finalized by 1 or more of the attorneys. It's been our experience that in most cases, this minimizes the cost of document production while allowing us to monitor quality control for the documents that we do produce. Sometimes documents go through more than 1 cycle of edit, review, and redraft, being sent back for further research or other work before being finalized. We've still found that this is usually the most economical approach. The way we keep our clients informed as to the status of their cases is to copy the client with every piece of paper that comes in and every piece of paper that goes out. We ask the clients to simply keep all the stuff that we mail them. Their files should look exactly like our files as the case progresses. The only things that we don't copy are things that we're not allowed to copy, or our phone notes, which aren't particularly useful in any case. In law, very little that's of great importance happens over the phone, and if it is terribly important and it happens over the phone, the first thing we do is we write it down and memorialize it. So all you have to do is keep the copies that we send you, and your file should be complete at all times. This firm also has a phone protocol. Specifically, in my experience, 90% of what clients want to call to talk about is what I call operational data. Who is the, when is the, where is the, how do you, etc. I am usually not available, either because I am meeting with people or because I'm in court. So those that want to get ready and quick answers to the questions they ask will find it best to go through the case manager paralegals. We ask, therefore, since that's where most of the inquiries end, that all calls be made to the case manager paralegal staff in the first instance. Now, obviously, our case manager paralegals don't give legal advice. So if the question is one which requires something along the lines of, should I take the settlement offer? What happens if we offer another $5,000, etc.? They're not going to answer questions like that. They're going to pass them along to the attorney staff, who will then return the call. But unless there's a reason to call one of the attorneys directly, we ask for most calls to be made in the first instance to the paralegal case manager handling the individual case. Our billing procedures, retainer agreement, and consultation policies are posted on the website, and we pretty much require every client to read them over before coming in to even see us on an initial consultation. The reality is that not everyone who wishes to hire this firm can afford to do so. Our retainer agreement calls for a true trust retainer in what we call an evergreen arrangement. We send out monthly statements of what work was done and what fees were charged. What this means on a practical level is that the sum of the original retainer must be replenished each month and kept in place at all times until the end of the case, so that we are effectively paid in advance for all work and costs to be incurred. At the end of the case, any sums remaining in the retainer deposit are, of course, refunded to the client. All this is set out in detail in the retainer agreement posted on the site. Obviously, mistakes can happen, and most errors with billing can be resolved with a simple phone call to the firm administrator, who is the person here to whom all such questions should be addressed. If there really is a dispute as to any billing matter that cannot be resolved in such a phone call, we require being notified of it within 30 days, as detailed in the retainer agreement. If we are not notified of a dispute within that time, the bill is considered final. We've gone to some effort to spell out clearly and in great detail exactly how our billing and administrative procedures work for in-office work and court time, how matters are assigned and to whom, and who bills how much for what tasks. Again, we encourage anyone considering hiring us to review the retainer agreement closely and to ask any questions to how anything works in advance of hiring us. Finally, We do not and cannot guarantee in any case how long it will take, how much it will cost, or what the final outcome will be. During the consultation or throughout the litigation of a case, we will, of course, express our opinions as to what is happening or what we think should happen. However, it can't be stressed enough that no such comments are promises or guarantees of any kind. Litigation is inherently uncertain, and it would be impossible to predict length, cost, or outcome with any degree of reliability. So we make it clear at all times, beginning right here, that we are not making any such promises.